Hello. Well, I'm just getting things set up. I'm getting the code up. Shil. Oh, I see a mod in the chat. Shil, could you let me know how the sound is? Hey, Charlotte, how you doing? If one of you could just let me know what the sound is like, I am just setting up for the court to start. Make it nice and big. This is the first time we will be coming out of this courthouse. Well, not this courthouse, but this courtroom with Judge Steven Hippler. Okay. Hey, Christophans. Wow. Oh, I'm so glad to see you, Christopher. I haven't been making your lives because of the timing, but I have been listening. I do enjoy what you do over there on your channel with the collabs, in the improvs, in the music. It just makes my day. I often listen to you. A little secret for you. I often listen to you while I'm working on my research. I love the music. I absolutely do. And I hope you continue to grow. I really do. Thank you, Charla. My sound is good because sometimes the internet gives me a problem. Um, I'm gonna keep it like this just to watch, but I think I will make the court. I'm thinking about using a different layout for when the court starts. Um, Maybe this one. No, yeah, maybe that one. And I think I'm just going to edit that one actually. Let's see. Let me just put that. Oh, I have to get rid of one. Mm-hmm. No, I don't like that one. Okay. I'm going to have to just make it like I think full screen like this and just keep myself off to the side. Or actually, it's okay as a square, right? I'll have to fix it later. Although I do like the circles much better. I do enjoy the circle now. Oh, you do? You watch? Oh, oh, I'm sorry, Christopher. And always, you know who I thought? I thought you were Christopher. I just saw the beginning of it. I'm so happy to see you. I haven't seen you in so long here. Please forgive me, Christopher. Christopher, and always, I know. Yeah, I used to see you in the chats all the time, and I'm thinking Christopher Music Channel, which is another channel that I follow. I'm so sorry. Oh, Charlotte, I'm so happy. I'll let you know what I do here. If it's your first time, Charlotte, I do not talk while the court is in session. Maybe if they do a sidebar, I'll pop up. But otherwise, I really try not to. I really try not to. I do believe. I think this one's okay.
All rise.
And on that, I'm gonna mute. We're gonna listen. Here we go, guys. And hey, there, Quiz. Good to see you. Welcome to Judge Hippler's court. Let me make sure he's all the way up. How is the volume with the court before they get started? Very interesting view.
All right. Good afternoon. This is State v. Kohberger. I want to go over the appearances this afternoon on behalf of the state. Would state attorneys please represent themselves for the record?
Thank you, Your Honor. My name is Bill Thompson. I'm the Latah County prosecutor. This is Ashley Jennings. She's my senior deputy. And then we have Mr. Nye and Ms. Beatty from the Attorney General's office. And then we have victim support staff with us.
All right. Thank you.
Yes, sir.
Defense?
Ann Taylor, attorney for Bryan Kohberger, Elisa Massa, and Jay Logston, counsel for Mr. Kohberger as well.
Thank you. All right. Like to tell you I'm happy to be here, but why start with an untruth? I am accepting of my responsibility to be here. I want to go over with you some expectations of mine, given that I don't think any of you, other than Ms. Massoth, have appeared in front of me before. When you file memorandums of law, briefs, etc., please provide a Word copy by email to my staff attorney. After today's hearing, you may get that from staff here today. Today, I know there was an issue that was brought up with respect to Mr. Kohberger's attire for today. I did issue an order yesterday permitting him to appear in civilian clothes for this hearing only. That is a matter in terms of future hearings that we will take up in a closed hearing the day of, but in advance of whatever our next hearing date will be. My intention will be that Mr. Kohberger will not be present for that hearing because part of what we will be discussing are security measures. And I expect to hear from the transport deputies and the bailiffs regarding security issues that they want to address or that I have questions for them about, so that I can make an appropriate ruling in terms of his appearance here, but weighing that not just against, of course, his rights, but also against the needs of security in this case. I do expect, as it probably will come to no surprise to you, for you all to get along. I understand the stakes in this case are as high as they can possibly be in any case, but you are professionals. You have taken oaths, both as of officers within your jurisdictions, but also as attorneys before this bar. So I expect at all times for you to remain civil to one another, that you not engage in personal attacks, ad hominem attacks, that you not engage in theatrics, not misstate the facts or the law to the court, and that when you cite arguments in your briefs, if there is contradictory precedent, I expect to see that. I appreciate in advance what should go without saying that I've just said in terms of your responsibilities. But again, I just want to highlight that because I understand when the stakes are high, sometimes victory seems to be the objective when our first objective is to conform to the oaths that we've taken as members of the bar, as officers of this court. All right. I do have some matters with respect to scheduling that I want to go over today, but before I do that, I'd like to hear from you with respect to the matters that you either need to make me aware of or want to make me aware of. The other thing before I do that, though, I do know that Judge had entered a non-dissemination order. That still remains in place. And unless I, for some reason, remove that order, it will stay in place, and I expect it to be religiously adhered to by all parties, counsel, victims, counsel for the victims, and I will not tolerate violations of that. Likewise, I know that much of the evidence in this case has been subject to orders sealing under that dissemination order or otherwise have been sealed by the court. I likewise expect everyone that has access to that information, whether it's sealed documents or information in sealed hearings or the information itself in the documents, to adhere to the confidentiality expected as it relates to those. Okay, that's my one and only lecture for you for the remainder of this case. With that, let me hear from you. We'll start with counsel for the state.
Your Honor, I don't know that we have specific questions we want to propose today. We're looking forward to hearing the scheduling. I think that's going to drive for us, particularly the distance involved, any questions that we may have. I appreciate what you've already mentioned to us, and we will certainly honor all of that. Thank you, sir.
Taylor?
Thank you, Your Honor. There are a few issues that I wanted to make the court aware of as the court decides on the scheduling order. We want the court to know that our team has been working towards the June of 2025 trial date that had been issued by Judge in the case. But in candor to the court, I need to let the court know some issues that have come up that we face that causes me concern. First, I think the court's probably aware of the vast amount of discovery that's been exchanged in the case by reviewing the record. But since August, we have received about 398 gigabytes of new information, and I can tell the court that nobody on the team has read every bit of that yet. So there's a vast amount of discovery to continue to go through, and I wanted the court to be aware of that. The second thing is that during the course of this case, we had an expert that we were working with, and that expert passed away. We have been able to refill that role to have a new expert to do the work that that expert was hired to do, but we are not progressed to the point that I'd hoped to be through no fault of the new expert. The court should be aware of that as well. And last, as the court is very well aware, the system of delivering public defense is changing next week. As appointed counsel in the case, I do not have a contract yet. Nobody on my team is under contract for this case. I'm concerned about what that means, and I thought the court should be aware. Further, we have been able to access funding to help us prepare this case through Idaho Criminal Rule 12.2. At the current time, we're working with about 25 experts and investigators to prepare the case. I don't know if 12.2 will continue to be the way to get funding for those experts and investigators, or if that's changing. And I thought the court should know those things. Thank you.
Thank you. So I am hopeful that Mr. Frederickson will ensure that the contract is available for you and your team next week. I have no control over that, of course, other than to, as it relates to who I permit to withdraw from this case or not withdraw from this case. As to 12.2 funding, my understanding is, and I've had a discussion with Judge Munson, who has been serving, as I understand it, as what we refer to as the money judge. I've asked him to remain in that capacity at least through the transition to the state public defense system in next week on October 1. My understanding is, and perhaps I will come to find out something different, but that once it goes to that system 12.2 as it relates to public defense funded attorneys on contract seeking 12.2 funding, that's no longer a thing. That would come through the state public defense budget, essentially. I guess we'll find out if that becomes a problem down the road, but that's my understanding, because that whole system that 12.2 is based upon is coming to an end. So given your statement about the trial date, my proposal to move this case forward into May is probably not going to land well with you, but that's what I wanted to talk about, is the timing of the trial. I'm concerned with a trial as currently set for a number of reasons, but first I want to find out from you, as you sit here today, what that trial looks like in terms of the number of weeks of trial, starting from after a jury is selected through the end of the evidence and before any potential sentencing phase. So what are your estimates of that?
Your Honor, I think it would be a fair estimate based on what we know at this point to have a month and a half or perhaps a bit more just for the evidence for the guilt phase of the trial. I say that knowing.
Is that just your evidence, or does that include defense evidence?
Well, I was just getting ready to say, I say that understanding or acknowledging that Ms. Taylor has estimated 2 to 3 months total. I do not know. We do not know what the defense has in mind for their case right now. So all I can speak to is what we anticipate for ourselves. But I would think the state's evidence in chief should be able to come in a month and a half or so.
Ms. Taylor?
Your Honor, we estimate 4 weeks for the defense portion of the trial case.
Of the guilt phase?
Yes, Your Honor.
So 10 weeks. In terms of if there is a penalty phase, should the defendant be convicted of one of the statutory qualifying offenses, how long do we estimate the penalty phase being?
Your Honor, from the state's perspective, I believe we're going to be relying heavily on the evidence that's introduced during the guilt phase, and that the additional evidence that would be brought in, unless there's something we learned from the defense about their experts, it is probably taking no more than a week.
Taylor?
Your Honor, I would estimate 2 weeks for that part of any trial,
That's
for our evidence.
for your evidence.
Yes.
Okay. So my concern, because this trial is currently set to begin June 2nd and end approximately August 31st, is having it set to run the entire course of the summer. I think we will find it to be difficult on jurors in particular. Jurors who may have children who are out of school, in terms of being able to spend time, go on vacations with them, et cetera. That's one concern. The second concern is with school that typically starts in mid to late August, and jurors or parents who may have kids going off to school, the timing of that through August. And that's my primary concern about that time frame. I had two proposals. One was to start the trial in the evidence portion of the trial the first week of May. And the other would be to start the evidence in early September. And I'd like your thoughts on those. I'm not saying have or necessarily will vacate the June trial date, but I want to look at alternatives here because I am concerned about that spread that takes the entirety of the summer.
And we hear you, Your Honor. By way of history, the summer, we advocated for that in Latah County because the courthouse is right across from the high school and the summer would have the students gone. If we were looking at the other two choices, we would propose May.
Taylor?
Thank you, Your Honor. Your Honor, I would have to advocate for September at this point, based on the 3 reasons that I gave the court before.
So I'm not going to worry about the public defense change because I think that will take care of itself. The one thing that you brought up the most, I mean, I understand there's a lot of evidence, but May is not tomorrow. May is many months away. So the one that concerns me that you brought up is your expert. I'm not asking you necessarily to give away any secrets prematurely that you may have in terms of defense strategy, but can you help me understand this expert if you're able to, and what their role is and what the prospects are?
Your Honor, it's really difficult to tell you much about the expert without giving away a lot. I can tell you that this is a very necessary expert for us to have on board. We've been able to find somebody to fill the role. I'm confident in the person that will fill the role. There just hasn't been enough time to get the work accomplished yet. I know that that doesn't tell the court a whole lot more than what I said before, but I really feel that that would disclose too much for me to say more. I could do so on an ex parte basis or with Judge Monson, our resource judge, but not in a public setting.
I understand. Do you anticipate being able to fulfill your obligations for your current expert disclosure deadline that was set by Judge?
No, not with a lot of confidence. I think that the work is going to take longer than to meet that deadline. I think if we met that deadline, I would have additional information that I would want to be able to present. And maybe I would have been stopped from that with that deadline.
So I don't have a motion to extend that date, obviously, and with the changes that occurred, I understand why you didn't file one out of the box, but the deadline, I think, is January 6th, something like that, if I'm not mistaken, for experts on the defense side.
That's one of our deadlines, Your Honor, yes.
I guess the state have anything to say in response?
Not knowing the details of the challenges Ms. Taylor and her team are facing, I don't really know how to respond further, Your Honor.
What do you think is a realistic deadline for you to be able to disclose your experts for everything? I'm assuming it was January, all save that one expert. But with respect to the expert you had to replace, when do you think you could disclose consistent with the scheduling order?
Other than the expert that had to be replaced, Your Honor, there were two separate deadlines. One was for trial experts and one was for mitigation experts. And I believe that I can make that deadline other than that one expert.
Can you tell me if the one expert is a mitigation or a trial expert?
A mitigation expert, Your Honor.
And what do you think you need for that mitigation expert in terms of a deadline? Compared to that mitigation deadline was,
I believe it was March. I don't recall the exact date.
yeah, so that's a long time from now. So, I have a lot of questions, but I'm hesitant to ask you the questions because I'm sure you're not in a position to answer them currently, given the forum. So, but March is a long time from now.
Your Honor, the time passes very rapidly, and I appreciate the court not asking questions I can't answer. I think if I had an end of April deadline for that one witness, I think we could make that deadline.
So understanding this is a mitigation expert, Thompson, how concerned are you about getting that disclosure closer to trial?
Closer to trial is somewhat relative. The end of April sounds like it would be on the eve of trial from the date the court is proposing. I think that would be, I'm not sure that would be realistic. And again, I'm not in a position to second guess
Sure.
what Ms. Taylor and her team are representing to the court. She had told us some time back that one of her experts had some health issues, and I think that she did tell us that that person had passed away and they were working on a replacement. If we're looking at a mitigation disclosure at the end of April, I don't know that we could be ready with all the final trial preparation for a May trial. I hate to say that and feel like
Sure.
I'm cutting my own throat in a sense, but that's realistic.
Well, I can do one of two things. I can set a separate hearing ex parte to explore this further, but frankly don't know how far that's going to get me. I mean, I can set a date, and my experience tells me that date will be complied with regardless, right? 24 hours in a day, but if you use enough of those hours, enough days in a row, you get it done if you have to. At the same time, I don't want to put unrealistic deadlines. And so I can do that. I can have an ex parte hearing, or we can go ahead and reserve September. I will throw it to you, Mr. Thompson, is what you want, what you would advocate for.
Your Honor, could I have just a moment? Your Honor, we trust the court to do the ex parte hearing, see what's there and make the best decision and tell us what the expectations are.
Well, do you want to do that later today, or you want to do it tomorrow? You need more time? You want to come back next week?
Your Honor, I had planned to leave town today. I have other case-related obligations tomorrow. I could do it as soon as this hearing's over if the court has time, or I can come back next week at the court's convenience.
I think we'll probably be finished in here by 3 if we were to do it immediately after. Are you comfortable with that? Does that give you enough time to get to the airport?
Yes, I believe it will, Your Honor.
All right. Well, we'll give that a shot. All right. If I move this one way or the other, I will adjust the various deadlines that are in here. I won't adjust the next deadline that you have, understanding that you may be already committed to it, which I think is the motions related to the defense's motion regarding the death penalty, if I'm not mistaken. Is that the next set of hearings that we have?
Those are now scheduled.
I believe that our briefs are due the 10th of next month with a hearing later this fall and a reply brief deadline for the defense. And we are on track to meet those deadlines, Your Honor.
I'm sorry, you were saying, counsel.
Your Honor, I'm guessing the court has received our motions already. I believe we were set for November the 7th.
I think the state's deadline for discovery has passed. Has the state complied with its discovery obligations, including those outlined in judge's last order and other orders?
We have, Your Honor, and in fact, Ms. Jennings prepared a lengthy summary of all the discovery that was filed with the Latah County Court when our discovery deadline hit. It is lengthy, but there's a lot of discovery.
Sure.
We recognize
How
that
much of the, would you say 300 gigabytes?
398 since August 13th.
How much of that is new information?
Ms. Jennings could speak to that.
Ms. Jennings, can you speak to that?
Your Honor, the defense was given, and I'm not sure if this is what they're referencing, but they were given a copy of the OneDrive from the FBI. Most of that was cumulative discovery that they had already received in another fashion. I'm sure there were portions of it that was new information. I don't. I've not calculated how much of that was new. So I can only rely on Ms. Taylor's, what she's represented to the court on that.
Well, I don't think she knows because it doesn't sound like she's looked at it yet.
All of it, Judge.
All right. Well, I will talk when we're finished here with Ms. Taylor without the state present in a closed hearing. What else do we need to talk about today, or do you want to talk about today?
Nothing comes to mind right now, Judge. I know that there will be plenty of opportunity for other discussions. As far as your meeting with defense ex parte, do you want the state for any reason to stay around, or would you like us to get on the road back to Moscow?
Are you flying or driving?
Driving.
Okay. Well, why don't you hang around just in case we need to, if I'm able to make a decision based on that, I can inform you what that is at least.
Yes, sir. Thank you.
Anything further, other than your your motions regarding the death penalty? Do you have any outstanding motions and the motion as it relates to Mr. Kohberger's attire?
Your Honor, there's no outstanding motions right now. I do anticipate filing several motions in the motion to compel deadline. As far as discovery goes, I anticipate there may be some follow-up motions. I, of course, will first try to speak with the prosecutor to resolve those.
I think you will find I'm probably more inclined to hear things more quickly than you're perhaps accustomed to in this case. So just be aware of that. It'd probably be more along the usual, 14-day timeline with respect to motions. If there's a lot that needs to be done with respect to them, we can talk about that. But okay.
On that point, Your Honor, as you can see, they're a multifaceted team. And on motions, we try to assign them to specific attorneys. On various motions, would it be acceptable to the court for those attorneys who are not actively arguing the motions to be able to participate remotely? Or would you like us to be present? We're happy to do either.
I'm fine with that. I just prefer those that are going to be arguing to be here, just because it makes it easier to have that dialogue. So.
Okay, thank you.
The others, if they want to appear remotely, that's fine.
Thank you.
And same for defense as well, depending on what defense wants to do. Okay. All right. Then if there's nothing else this morning or this afternoon, I guess we will be adjourned and have a discussion in a few minutes. All right. All
Thank you, Your Honor.
right. Back in a few minutes once the courtroom is cleared.
All rise.
Okay, so he said they would be back in a few minutes when the courtroom clears. So I guess they're going to be having that discussion on camera, which at first I was not so sure about. So I'm going to hang out for a little bit and see what happens. They're going to clear the courtroom and then come right back in. So that shouldn't take more than 10 to 15 minutes. So I'm kind of happy to see you guys here. Oh, let me just do this. I'm happy to have a few of you here to talk to. That was interesting. This judge seems to really want to get a good handle on the schedule and stop some of the delays that have been happening. I know Ann Taylor, an excellent defense attorney. She's doing everything she can for Bryan Kohberger, as he deserves a fair and just trial. But she's a bit pushy in regards
The big problem is having to hold it down
her
like
needs,
that.
as far as because she travels and she's got a busy practice. And, I did get the feeling that she pushed Judge around a little bit.
Gotcha. Nope, he didn't die.
Even
Oh my
alluding to
god,
the
I thought
fact
that would kill.
He was
Charging
being
the talisman
unfair
is
because he
getting
had a
my butt
prior
fucked.
relationship with prosecution. I mean, she was a bit wordy, I would say, in what her needs were, and she expected everyone to bend over
Thanks, Amy. You
backwards.
said
I
Taylor.
remember
You're
her
doing well.
having a fit about a
Doing
last
right.
minute motion
You're doing well.
when she's done the same. Because she had other clients to attend to, and her schedule didn't permit her being able to respond personally. Now she has a practice with an office, and she has a team. There are 3 attorneys on the defense team. So at the time, I thought the argument was a little like, yeah, it's not all about you, Miss Taylor, although I understand it's frustrating, you know? Oh, you got background noise? Because I turned
Cringe.
it down. What kind of background noise do
Bitch.
you have?
What?
Because I did mute the channel until it comes back up because they're
I
playing
thought the lasers were
like
gonna
ads
insta-kill
and
him.
stuff.
Misread that. Huh.
Yeah, because actually they took the actual whole thing down. They're not even on, like they ended it. Yeah, but I muted the whole thing. So hold on, let me just stop sharing it. How about now, Juju? I did hear it for a few seconds, and then I got rid of the stream. Okay, so Law and Crime is saying that they are just paused for now. But instead of leaving that sign up, he did take the whole thing down. Oh, that's okay. I'm glad you did, Juju. Thank you. I appreciate it. Hey, Maya. I don't know how long I should stay up, but I'm going to I am going to keep it up for just a bit. You guys have any questions? I thought it was interesting. Those of you that saw Juju, I know you were driving and you can't type. So I don't want to, if you're still driving, I don't want you to type. But if you're not driving, I would like to know what you guys think of the new judge. I for one am kind of impressed, actually, because it seems like he wants to keep this on schedule. He definitely doesn't want anything going on as far as like, delays or whatever. He expects everybody to be adults. He expects everybody to keep on that. He basically told them AKA keep up. Like he's already looking to change the trial date, and that's what they'll be talking about today because he wants it either in May or September, and he wants to decide now, not a week from now, not 2 weeks from now. He said, okay, we'll talk about this today. And I'm impressed. I agree with Charlotte's comment. She said she thinks this case needed this judge, and I do agree. I do like Judge. I think he did the best he could, but he did get pushed around a bit. I think by both sides. He really did. So I'm kind of happy to see like somebody who's just like all business. Well, I'm going to wait just a little bit. I have the other, you know what? They took the live off. They're done. Ex parte usually means in private, any like off, like to the side, like extra. They are not, I've never seen one actually, or I'm not remembering anyone that was actually live. The new Juju, the new judge it looks like he wants to keep everything on just right on track. He's actually asking them to reaffirm all the dates for when their motions had to come in, and he did mention that the June date is not going to be good. The June 2nd trial date is not going to be good for his court. Because it goes through to the end of August. So he is actually asking them to consider May or September. And Taylor said she couldn't be ready by May. Taylor came forward and said that unfortunately one of her expert witnesses after a bout had a health concern and has passed away and needs to be replaced. and she wants more time, of course. But the judge pushed back and said, like, that's not due until March, and that's plenty of time. Well, the new view is a little rough, Juju. I will tell you that. Ed Taylor's going to have a rough time keeping up with schedule because he didn't really want to hear her travel concerns. He said, I'm sure we could talk and you could still make your plane. She tried to put it off to next week. And he's like, nah, he'd say, won't you make your plane anyway? And she was like, yep, she has to agree. He's really holding their feet to the fire about what their actual needs really are. Like, if you're going to tell them you need something, you better be sure that's exactly what you need. And as far as the view, well, I couldn't do anything about it, but every time the prosecution stood up, his head got cut off. And most of Ann Taylor's too, or the way they have it, the judge is really low with too much above him, and they are very squished at the top. And when they stand up from the desk, they're all cut in half. Like, we were speaking to his chest. His chest was talking to us. Mr. Thompson, it was a pretty tall guy, I guess. But yeah, I hope they do something about that view. But everything disappeared. So anyway, that was interesting. That was definitely interesting. This will be, the link is in the description to the court that will be doing the live streams for those hearings that we can actually hear. The court order is still in effect that nothing can be live streamed, no cameras or anything in the courtroom. They will conduct it all themselves. And we'll only get what comes through the feed, just like before. He already did say that the two outstanding motions, the death penalty motion, the dates, he's pretty much sticking to those currently the best that he can, even though he asked both sides. Also, he decided to do the attire motion that the defense has. In other words, Bryan Kohberger is requesting to wear regular clothes and to not look shackled or overly guarded while he is in the courtroom. And that's a prejudicial issue. It comes up often in murder cases. Everybody would say, like, if you see a lot of guards around a person, it gives them a threatening and kind of a vibe to the jury that there's some concern there. Although the prison, because it is a multiple offense, remember, there were 4 murders here. Murder is a very serious charge. It's a felony. Of course, they had the prison itself, in the courtroom itself, has to keep the safety of everybody else in mind, and they have protocols. So they're going to be discussing that back and forth. I do believe they're going to allow him to wear regular clothes, but I do think he will have leg shackles, perhaps not hand shackles. So as long as he gets seated before the jury comes in, and he does not he is not removed while the jury is seated, they will not really have a good view of anything in that manner. And that is common to be how they actually compromise in these situations. But who knows? This judge seems to be a bit of a stickler. I don't know. I am very curious. I can't wait for the death penalty hearings. I think that's going to be quite the back and forth. There were quite a few motions filed already on the defense, and they were very, very thorough. There's a lot of case law there. There is a lot of expert witness there, but that's part of the problem is with the expert witnesses. Ann Taylor is running into some scheduling issues with the expert witnesses, which she conveyed to the court. Juju says, I like the sound of this judge. This is Ann Taylor's hawing so much about going. Yep, this is it. Yeah, she'd also want May. She said, as I previously stated in the filings, like in other words, like, I'm not going to say it again. Go back and read, Judge. And he was just like, oh, what do you think, prosecution? But the prosecution also hesitated because Ann Taylor is going to be moving the date for when she can expect to have all of her motions and all of her expert witness stuff in. and it was very close to the trial date, like the end of April. And so prosecution had a concern, Juju, about that, because if the trial got moved to May, they would only have a week to answer stuff. And they know how she files. I mean, we've all seen it. Her files are extensive, okay? And she's got Jay Broggs in there too, in his filing. We just saw it on death penalty. My God, 1,000 pages. Yeah. 1,000 pages of exhibits and case law and stuff to go over for all of those motions prior. But we don't have that many outstanding right now. Just the attire and security motion, and also the death penalty motion are the only things that have been left unordered on by Judge. And reasonably so. I mean, there was no order due because they haven't even had the death penalty hearing yet in regards to what they're going to do about that when they get to do the oral arguments. But I think since they're not coming back, if they do come back, I am going to record it for you and I'll put it in the playlist. This one will be in the playlist for all of you coming by later, wondering what happened. We'll keep it up to date. Any of Bryan Kohberger's hearings that are live that don't conflict with another hearing that I'm doing, I'm going to try to get them recorded and in the playlist for you. If I can't record it myself with a live stream, I will at least get a copy of it and list it in there so we can keep abreast. Because I think this is going to be moving faster now. I really do. This judge sounds like he's going to hold everybody's feet to the fire on scheduling in on needs and make them actually explain in detail what those needs are and weigh it out. Like it's kind of like instead of them all being on an equal playing field, it's like the adult entered the room and said, no, this is what we're doing. I mean, that's the vibe I'm getting. I don't know how you guys feel, but I do think that this is a good thing for this particular case. Tomorrow I'll be back at 2:00, a little before 2:00 actually. We're going to do Sarah Boone, which was delayed today, rescheduled due to the hurricane. I hope everybody in the path of that hurricane is going to be okay. I heard it's supposed to be pretty terrible with the surge in Florida, and I do hope that everybody is going to be okay. Hopefully it changes course out of their way. I'm not sure. I have to check the weather, but I've been thinking of them all and just wish everybody to be safe, you know, and protected. On that, I'm going to end for now, and I will I'll see you guys tomorrow. Have a good one.